I'd like to introduce Richard Dengate. He's a graduate of Central Michigan University and Wayne State University. He has a Fulbright scholarship and he traveled to India. He was a Michigan exchange teacher and went to Japan. He retired after 50 years of teaching in the classroom. He also currently serves as the membership director for the Rochester-Avon Historical Society. Mr. Richard, I know you have a lot to get through. So without further ado, I introduce to you Richard Dengate.
Well, good afternoon, everybody. A couple of preliminary remarks. Because I only have 1 hour, and there's an awful lot to go through, so I was going to ask everybody, if you have any questions as we go along, please wait till the end, and we'll deal with the questions at the end because of the time constraints that we're under. So, this is going to be about the basic document of rights that we've had for 234 years in the United States. But I want to proceed first to give just a thumbnail background sketch of how we got to those documents in their drafting and in their ratification. So everybody can hear me fine? And okay, good. So I put together a little chronology here. Let's just very, very briefly get down to the bottom one, and then we'll slip into the Bill of Rights. When we get to the Bill of Rights, I'm going to explain and introduce them as to what the original intent was and the historical background of it. We don't have time here to go into all of the interpretation of all of these issues in the documents themselves, that we be here for a month of Sundays. So let's begin with the chronology. In the mid 18th century, conditions and relationships between the colonies and Great Britain began to deteriorate rapidly. It was falling apart. There were 13 colonies, we all remember, and so for the first time, they got a meeting going in September and October of representatives, of delegates of the 13 colonies to have a discussion about these deteriorating conditions. What are we going to do about it? What's going to be our agenda? And that was the first Continental Congress. And preceding it was the Stamp Act and the Boston Massacre that really began to rile up the people in the colonies. So that was the Continental Congress, the first one. And then Britain sent the British Army here. And on April 19th of 75 was Lexington and Concord and the war. In May, a month later, they met again for the second time. The ones that were meeting in 74, they got together and says, okay, we got a war on our hands, what are we going to do about it? And that was the Second Continental Congress. And that is our first national government that took us through the war. And it was a 6-year period of time. Well, by 1776, they got together again, and Jefferson wrote the Declaration of Independence, and they all signed it. You remember what that was? That was a death warrant. When they signed that document, if we had lost the war, they'd all have been taken back to Britain and hung as traitors. And so by 1781, March the 1st, the war was over, Yorktown, and so forth, or towards the end of the war, and they realized if we win this war, which was not likely to happen, because they had to beg the 13 colonies to send troops. And so they decided we've got to get together and we've got to draft a governance document. Because if we win the war, we're an independent sovereign nation, how are we going to govern one another? So they drew up the Articles of Confederation. September, October of that year was Yorktown, the last battle. The war, the shooting war, ended. And the Articles of Confederation was the second governance document that we lived under, and that was going to take us up to the Constitution itself. But there were terrible, terrible problems with the Articles of Confederation. How many remember the Civil War? It was the Southern Confederacy. Remember that? Okay. A confederation is a government whereby the national level is weak, relatively speaking, and the state levels or local levels hold the strength, hold the sovereignty. There was no executive under the Articles. There was no judicial under the Articles. We did not have a national currency. There was a problem with foreign affairs. Who's going to decide foreign affairs? If France wants a relationship with the United States, who do they talk to? They talk to Massachusetts, they talk to Georgia, they talk to Delaware. Which one of the 13 colonies, well then it would be states, of course, which one do we talk to establish trade and so forth? There was no way to raise an army. There were 13 militias. If we get into this trouble again, how are we going to get out of it? So there are all these defaults. There was no power to tax. So, no central authority. By 1783, the Treaty of Paris, that treaty was a result of the war and settled it politically. So in 1787, or those 4 years now, they had a conversation about what are we going to do. Are we going to amend the Articles of Confederation? Well, we can, but the Articles of Confederation required a unanimous consent to do any amending. Nearly impossible to do. So in Philadelphia, in the hot summer of 1787, 55 delegates from the 13 now states met on Market Street, very hot summer, and they decided to write an entirely new document. And they flipped the political structure from a confederacy to a federal system. The power was going to be transferred from the 13 states to the federal government to tax, uniform currency, raise an army, raise a navy, et cetera, et cetera, et cetera. But they had a problem because Americans at that time are very, very suspicious of a strong central government, especially when it came to the experience they had with the Brits. Rights. Britain didn't treat us very well. But then again, we were not very good colonists either. We expected Britain to come over here and build our forts and protect us and all that stuff. And remember the Tea Party? We not only didn't want to pay the taxes, we threw all the tea overboard in defiance of that. So it was a mutual non-admiration society. But the folks at the time, once again, were very, very suspicious. Very suspicious. They wanted rights defined, and they wanted them to be very specific. Now, so in those 3 months of 1787, they got to work. 55 delegates. to write the document. I'm going to jump a little bit here. The original Constitution had two rights mentioned in it, in the original document. I'm going to jump to it. One was the privilege of habeas corpus. Let me back up here. The privilege of the right of habeas corpus shall not be suspended unless in case of rebellion, invasion, public safety. This is a basic document of democracy. Habeas corpus is you cannot arrest, detain, prosecute without bringing the suspect before a judge, that's the judicial branch, which the Articles of Confederation didn't have, to determine the legality of the detention. When we read of totalitarian states, it's the proverbial knock on the door at 3 o'clock in the morning and off goes somebody and they never hear from them again. They built that into the original document because of the abuse, and it still happens today. People disappear. In this country, if you're detained, you've got a right to be brought before an impartial judge to determine the legality of that detention. Protection against capricious and arbitrary arrest. That was in the original Constitution coming out of the convention. The second one was treason. Treason is a broad charge. They don't like the way your hair or your color, the totalitarian state, to charge you with treason. And God knows what happens to you after that. They wanted something specific about what is it that causes, that determines what is treason. So again, no arbitrary charge of treason because they don't like your politics. So here's what they wrote. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on testimony of 2 witnesses to the same act or confession in open court. That has never been implemented. That has never been implemented. Some will say, what about John Brown prior to the Civil War? John Brown was hung for treason, but under a state law. The federal government has never prosecuted, charged anybody for treason. Some people say, what about the Rosenbergs? Remember the Rosenbergs? They were charged and executed for espionage. That's not treason. That's how tight that is. Okay, so those 2 things. And I should mention, let me back up here. Habeas corpus can be suspended for rebellion and invasion. The only time this was ever implemented was the Civil War in Lincoln. And then there was an argument about that is, does the president have the right to suspend habeas corpus, or is it Congress? Lincoln argued, of course, it was president, and he did it, suspended habeas corpus. All right, so let's go back. 1780 to 1788, and the Constitution was drafted, and when Benjamin Franklin stepped outside of what is now Constitutional Hall, a lady by the name of Mrs. Powell approached him and said, Dr. Franklin, what kind of government have you given us? And he said, a republic, madam, if you can keep it. So, now we get into the ratification, and the people in the country demanded more specificity on rights. Well, they didn't want to go back in to start to rewrite the document that they had just finished. And so they made a blood pact with the country. If you ratify this Constitution, the first order of business of the Congress will be to draft 10 rights amendments to the Constitution. First order of business. There was also the Federalist Papers. Alexander Hamilton, Thomas Jefferson, and John Jay wrote 85 articles. Pardon? Madison, yeah, thank you. Madison wrote 85 articles encouraging the adoption of this new document, this new Constitution. They're called the Federalist Papers. They appeared in practically every newspaper in the country at the time. So the Constitution eventually was ratified. We got to get going here. Okay, good. It took 9 of the 13 states. They corrected the Articles of Confederation by saying no unanimous ratification. 9 of the 13, and it was ratified. Well, okay, so now we come to 1790-91. And between those 3 years, they sat down and they drafted the 10 amendments. Actually, there were 12. 2 were not ratified. Ironically, I keep my dates right here. Ironically, one had to do with how you're going to apportion the House of Representatives according to population. It got into all kinds of dead ends to it. They deep-sixed it. The other one was that they could not increase their pay until any increase in pay for them would apply to the next session of the Congress. They couldn't give themselves a raise. They defeated that one. Ironically, that one I just mentioned became the 27th Amendment to the Constitution. It was ratified in 1992. So it made it finally all these years later. So we have now the Bill of Rights. It was, they got through with the 10, they ended up with the 10, and on December 15th, here's what they had. Now, this is called the expression, the expression amendment, freedom of expression, that in the jargon. The first is called the Establishment Clause, and the next one is the Free Exercise Clause. And they mention religion, speech, press, assembly, petition. 5 of them. Freedom of expression. All the freedoms here are relative, not absolute. We have freedom of speech, yes, but we can't, as the Supreme Court Justice, I forget who it was, maybe somebody can remember, said, that doesn't mean you can cry fire in a crowded theater. You can't libel, you can't slander somebody. But we are free to express especially our political thoughts. That's essential to a democracy, back and forth. But they also found, of course, it applies to the speech, the oral, and also to the printed press. We have the right to assemble into groups. No atomizing society, breaking people up into various groups. And we have the right to petition the government. Does that mean that we have to allow all groups to express themselves? Answer, yes. No matter how vile they are. Case a few years, no, more than a few years ago, when the American Nazi Party wanted to march down in Skokie, Illinois. Heavily Jewish community. And it went to courts. They said, yes. Popular speech doesn't need to be protected. Unpopular speech needs to be protected. The written and the oral. And sometimes that's hard to do. Nobody likes a bunch of people marching down the street carrying swastika flags, but see, democracy can be very hard. You have to be very patient, very tolerant. I disagree with what you say, but I will defend to the death your right to say it. That's what democracy is supposed to be about. Well, they put that as really as number one. So now here's the one that's going to give us a lot of trouble. I doubt whether the 55 people who drafted this document realized how much trouble this was going to give us. Right? There's two clauses in there. One says a well-regulated militia being necessary to a free state. The people's right to bear arms shall not be infringed. And we're struggling with it to this day. I would like to be able to bring back a couple of those drafters of this and let them look at the newspaper and the news coverage and say, is this what you guys intended to? But that's give us. When I taught in Japan, I was repeatedly asked about this. And both in India too. People did not understand what they were seeing and reading about gun violence in the country. We struggle with this. And we're not settled with it yet. And we may never settle with it. That's hard when you're in a position you've got to try to explain when people from a foreign country ask you questions about your country. You know how I answered it? I said, you got to understand, America was the only country on the planet where we landed on the East Coast and literally shot our way to the West Coast. It's in our culture. All you guys, and maybe some of you ladies in here, when you were kids, did you ever have a play gun? I did. A belt? Yeah, I know, yeah. But I did. I'm 84 years old. When I was a kid, me and all the kids, it's part of this, and we're struggling with it. But there's not been any country ever that had this kind of a heritage. But in those days, it was a young country, it was wide open. We're very different today. But anyway, we'll move on. Now, this is interesting too. This is the third one. Okay. What's that about? Well, they being the folks back in 1787, 1790, 91, they knew they had experienced this sort of thing in the colonial period. Because British soldiers would come over here, and that until 1765, they would place their soldiers in public housing, in public places. But in 1774, they began to house the British soldiers in private homes. And so those folks back then said, we want something in there saying, we're not going to do this anymore. So that's what this one is about. No soldier shall, in time of peace, quarter any house without consent of the owner. And you can appreciate this 230 some years ago, those people who wrote this stuff were in fact the intelligentsia of the country. They were very smart. They grew up and were very familiar with the Enlightenment, the British, the Scottish Enlightenment. Hobbes, Adam Smith, David Ricardo, David Hume. And so they implemented a lot of this. They knew how to say it, and they provided for it. You can appreciate that. Okay, so now the Fourth Amendment. The Fourth Amendment is called the Privacy Amendment. So let's look at this. The right of the people is secure in their persons, houses, papers, and effects against unreasonable searches and seizures. So what is unreasonable? Well, shall not be violated, and no warrants shall issue but on probable cause supported by author affirmation from, again, the judicial judges, describing the place to be searched and the persons to be searched. We in this country don't have general search warrants that used to be issued by Britain during the colonial period. The Brits would come in unannounced on a fishing expedition, as we call it, and just go through people's effects, their property. People at times we want something very, very specific about this because we've been victimized by this sort of thing. So first of all, you need a search warrant. If you're going to, if your privacy is going to be impugned, you got to have a search warrant. The search warrant has to say, first of all, it comes from a judge. That's why you got to have a judicial department. We didn't have one under the Articles. You got three things. You got the legislature, you got the executive, you got judicial. Comes from a judge. You got to prove there's probable cause that you want to penetrate the privacy of a citizen. And if you convince the judge that you do have probable cause, and here it is, then in that document has to say, where is it, what is it, the place to be searched, and the persons or things to be searched. As I said, no general search warrants, no fishing expeditions. We're going to go in there, and whatever we find, we're going to use against you. Not here. Very specific. There are exceptions, like a movable scene of a crime, and you don't have time to get a search warrant. You will have to get one post haste. But generally speaking, you got to have a search warrant. It's got to be specific. Privacy Amendment. And of course, this has caused, once again, bring some of these people in who wrote this and show them the internet and show them our electronics and our technology today. This has turned Privacy Amendment upside down, inside out. Hacking. Our privacy is really, really challenged now. Really challenged. But if they want to go and to search your computer, it still applies. What is it you want? Computer. Why do you want it? I'm speaking of the judge. What are you looking for? And if they find something else, they can't use it. It was an illegal search. Privacy, big issue today. Now here's a big one. Okay, so let's look at it. No person shall be held to answer for capital or otherwise infamous crime unless a presented of indictment of grand jury. Okay, we stop there. What is a grand jury? A grand jury's sole purpose is to collect evidence that would suggest probable cause. It doesn't determine guilt or innocence. That's the facts of the case, to be determined by what's called a petite jury. That's where you have your defendant and your prosecutor, and they lay the facts out, you're guilty or you're innocent. You, grand jury, solely determines whether there's evidence to warrant trial by a petite jury. You can have one person grand jury, a judge, or you can have a multiple grand jury. Like, I remember as a young guy, 57, there was a big investigation of organized crime in the country. Anybody remember that? I mean, it was 1957. I mean, they got all of the alleged dons and so forth and so on. That was I guess it was a 12 or 14 person grand jury. You can have something like that. How penetrating is this in the society? So, okay, so that's grand jury and petite jury. Now, everybody is presented of an infamous crime is guaranteed right to an indictment by a grand jury. Because what is also used sometimes, you can arrest somebody, put them on trial, even though they are clearly innocent, but even being tried for something and found innocent is problematic. There's a whole lot of folks say, well, there must be something there that he did, you know. So before you try somebody, you got to have enough of evidence. And the other thing about this is, acquittal is not the same thing as innocence. If I'm on a jury, if it's a civil case, it's a preponderance of the evidence is supposed to convince me that the person they're charged is guilty. If it is a capital felony, then it is beyond a reasonable doubt. So I'm on a jury, or you're on a jury, and the prosecutor goes through their stuff and the defense goes through their stuff, the petite jury, and you say to yourself, I'm not convinced that there wasn't enough evidence. The prosecution did a lousy job. They took it to court without doing their homework. I don't see beyond a reasonable doubt here, and it certainly isn't preponderance of the evidence. What do? You acquit. Doesn't mean you're saying the defendant's innocent. He could be guilty of sin. But you didn't convince me. So there's a big difference between acquittal and innocence. Not the same thing. Okay, so line of military, okay, so, and there we go to a double jeopardy. Twice be put into jeopardy of life or limb, nor shall compelled in any criminal case to be a witness against himself. So they have every right as a defendant. You don't have to testify. You can sit and let everybody else testify. But you can if you want. It's up to the defense. Put you on the witness stand to be a witness for yourself, and that's a big decision that has to be made. Let's see, witness against him, nor deprive life, liberty, and property without due process of law. All right, now what is due process of law? You appreciate how smart these people were that put this together. Because without this, there never would have been a constitution. Folks would never have voted to ratify that Constitution without these guarantees in it. And then where would we have been? Well, nobody knows. We can just speculate about that. Okay, due process of law. Nobody is going to be deprived of life, liberty, or property without due process of law. There are two due processes. One is substantive due process. That is to say, the law has to be constitutional. Nobody could be convicted of violating the law that in itself is unconstitutional, improper. Substantive due process. The other one is procedural due process. That is the process that was used from the time of arrest to the time of conviction has to be legal, legitimate, constitutional. If there's any flaw in that, the case is thrown out. We either try you again or you're free and clear. You remember that, do you remember that case in Minneapolis with the policeman who was convicted of killing George? I think his name was, pardon?
Floyd.
Floyd, yeah, thanks. He was convicted. Well, everybody's entitled to appeal. The innocent, you declared innocent, there's no point in appealing that. You accept, and you're free and clear. If you're convicted, you got a right to appeal to a higher court. Now, what is it that you're appealing? You're not appealing, well, I'm really innocent. That's already been decided at a lower court. You can't do that. Appellate courts, all the way up to the Supreme Court, here's cases on appeal. So what are you appealing? You are appealing either that the law that you were convicted of is improper, or the procedure somewhere along the line. You weren't advised of your rights and, this sort of thing. Or with regard to the George Floyd case. The policeman and his attorney, they appealed. And they appealed it said that, one, the jury should have been sequestered when the case was given to them to decide the case. And number two, there should have been a change of venue. Guy didn't get a fair trial. They didn't win, but that's an example of procedural due process. There's something wrong with the way this was handled. And so here we have no one deprived of life, liberty, or property without due process. Nor shall private property be taken for public use without just compensation. This is called eminent domain. They want to put a highway right down through town. Of course, this always happens. Eminent domain kicks in, just compensation to take private property, homes, tear them down. That's how I-75 was built, and I-94 was built. All of them were built that way. So why, that's my house, blah, blah, so forth. No, this is private property for public use. I can remember back in the 60s where I lived, they put not 696, 196 through Grand Rapids. And that cut right in front of the house we were living in. And as it proceeded, the houses were one after another. You remember that? She was with me. One by one, the houses were torn down, except one. Now, maybe she doesn't remember this. I came home from work one time, there's a guy in a bulldozer, and there's a little old lady out on the porch with a broom. I remember that. Anyway, and it's heartbreaking. I mean, these are people's houses they've been in for a long, long time. And so finally the police came and escorted the little old lady. It was sad, I mean, and with her broom. And the guy proceeded to take his bulldozer and bulldoze her house down. And now today, we ride over there, ride over it on 196 going into town. But that's this, eminent domain. They needed to have that in there to, once again, to prevent just arbitrary again and just compensation. So as I understand, when they pulled this kind of a thing, the assessor would go by, and identify all the structures that needed to come down, go to the records and see what the SEV on the property was, so forth, and appreciate it 10, 15%, whatever the case may be, to try to avoid any challenges, or as many challenges as could come up, that it wasn't a just compensation. But we have a whole new, different country today because of that, with all the roads and buildings, post offices, federal buildings, et cetera, et cetera. Without it, it'd be very different. So the Fifth Amendment is very big. Okay. The Sixth Amendment. All right, this is criminal prosecutions. Now, speedy and public trial. That was an attempt by these authors to prevent secret trials. How many, if you've ever read things of totalitarian states, speedy trial. You don't wait until people have forgotten or not here anymore, or the evidence has been destroyed or can't, that sort of. But not too speedy, where you're not allowed a reasonable amount of time to prepare for a defense. So once again, some of this stuff is arbitrary, and who settles it? The courts. It's the only thing we have at the courts. We don't want to leave it up to a president, or it's the courts. And that's why also at the federal level, judges are terms, are life. States, we elect the judges. The federal level, Supreme Court, district courts, appellate courts, all presidential appointments, confirmation by the Senate, and we're having one as we speak. Lifetime appointments. The idea behind that was we're going to take these men and women out of politics. But that's not working. So a lot of stuff isn't working like it used to. But that was the reason for that. They didn't want judges. I went to a few campaign for judges in my experience. They got to run for election. What does it take to run for election? Money. Where do you get money? You raise the money. I'd go to campaigns and I'd see lawyers there who are supporting so-and-so for judge, and then a couple weeks later they're arguing a case before the judge. It's So anyway, speedy and public trial by an impartial jury. There's where you can get into your procedural problems. There's where you get challenged. Anybody ever been serve on a jury? Okay, that's where you're challenged. I served on one up at Oakland Circuit Court, big-time felony. There were 13 of us. We sat through the whole trial. And we were challenged, before we got seated. And very last thing, right before the judge did his last thing, that is to instruct the jury what we could do and what we couldn't do, what we could consider, what we couldn't consider. The judge asked the clerk to bring the box up with the jurors' numbers on it. Oh, and the jury elected me to be 4 foreperson of the jury. They had 13 numbers in it. They were going to draw the one who would be excused because there's 12 people on the jury. So we're all sitting there, and guess whose number they pulled? The judge thanked me for my service, and I was excused, and to this day, I don't know how that case turned out. We had a chalkboard in the jury room, and I should have done it, but I didn't. I should have, here's my phone number. Somebody call me, let me know what you guys decided on this. I still don't know how that case came about. But anyway, an impartial jury. Now, as I said, you get into procedural issues here, and jury tampering. There was a case just a little while ago that was challenged, something that there was apparently an attempt to penetrate the jury tampering. The Rittenhouse case, yeah. Attempt to influence the jury, big time. That's okay. We got to get moving here. An impartial jury, and to be informed of the nature and the cause of accusation, confronted with the witness against him, and have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel. It took quite a while to implement some of this stuff. That is to say, if you can't afford a lawyer, one will be appointed for you. That's the public defender's thing. That didn't come till several years after this, what this actually meant and how you implement it. And also, back in the late 60s, I think it was also, and there's was the case where when you're about to be apprehended, you have to be notified of the charges against you, and you have the right to remain silent. All that stuff we're all familiar with now, that wasn't always the case. A lot of this came out of as recently as the 1960s. Yeah. Assistance counsel obtaining witnesses in your favor and so forth and so on. All right, we're on 7. Okay, here we go. This is common law now, where the value of the controversy exceeds $20. Now this is 230 years ago. The right of trial by jury shall be preserved. So even if you engage not in a criminal case, but in a civil case, we are still entitled, if we wish, we can have a bench trial. That's where a judge sits and decides the case. Or we can have a jury trial. Your call. What did you like? And shall not be re-examined. So whatever's decided, whatever you decide you want to hear the case, when they decide it, that's it. You can't take it any further. It's like, I understand Judge Judy. I understand that these people that come before her have to sign something that says that they will not challenge her decision out of this thing. So whatever Judge Judy says, that's the way it's going to be. So, well, you want to go before Judge Judy? I don't know. All right, so that's number 7. Now here's number 8. Excessive bail, excessive fines, cruel and unusual punishment. Now, in this country, can we take someone who's been convicted of robbery, thievery, and amputate their hands? Amputate their hands? Why? But now the important word here is cruel and unusual. Not or, and. It has to be cruel and unusual. Now, the most recent that I've seen is that they are now beginning to challenge chemical execution, because they are saying that the person is going through some excruciating, even though they use something like a downer, something that puts you at ease. And they certainly have challenged execution, electrocution. People really apparently suffer tremendously being executed. You know which state in the Union was the first state in the country to eliminate?
Michigan.
Michigan. 1849. And today, there are a lot of people who want to reinstate capital punishment. But you know another thing. Why should we keep these people alive for the rest of their life and at the expense of the community? Well, studies have shown it is more expensive to execute somebody than it is to keep them in jail for the rest of their life. Because on those capital cases, you're entitled to all kinds of appeals. It gets very, very expensive. So you're not saving any money. But, yeah, cruel and unusual, because they had experience with the dunking stool, you know. So anyway, excessive fines, excessive bails. You're going to pick up somebody for spitting on the sidewalk and put a $100,000 bail on them, you know. That's one way to...
Or les miserables.
Les miserables, yeah. Okay, well, we're getting towards the end now. 9. Now, they're getting towards the end of all of this stuff, see. They've mentioned an awful lot of things. So what they're saying here is the enumeration in the Constitution of certain rights, the ones that we just mentioned, shall not be construed to deny or disparage others retained by the people. What they're saying is, we can't sit here and keep thinking of all the possible rights that a human being is entitled to. What we're saying, whatever exists out there, we still have. Just because they're not mentioned up here, we haven't mentioned something here, doesn't mean that it doesn't exist, and 2, we're not entitled to them. It's a cover. So whatever they might be in another 100 years, 200, we don't know. And then they ended up with this. Good. The power is not delegated to the United States. In other words, the powers that we did not give the federal government in the Constitution, nor prohibited by it to the states, you can't do this in the division of powers, are reserved to the states respectively or to the people. This amendment is called federalism. There are certain powers given to the federal government, like supporting the military, conducting foreign affairs, and stuff like this. Okay. Then there's concurrent powers, like the power to tax. Federal government can tax, states can tax. Then there are prohibitive powers. Now, the states are given a group of powers called the police powers. Health, safety, and morals come under this. The federal government has no role to play in education. That is, to manage education. Education is a state function. The federal government can encourage the states to do certain things either by giving them money or taking money away. But they cannot legislate educational policy. That's every state. That's why we have 50 different educational systems. And below that, school districts. It's very fragmented. I taught in Japan. Japan is very different. They have the Ministry of Education in Tokyo, and everybody comes right under that. Every prefecture. We have a very, very disjointed or fragmented educational system. health, safety, and morals. Take the controversial issue of abortion that we struggle with. Every state has its own laws governing that. Nothing from the feds. And we have 50 different laws, and they're getting more diverse as we go along. It's part of the police powers. It's part of the the reserved powers to the states. So, that's pretty much the Bill of Rights, the first 10 amendments to the Constitution. As I said, without this, the people in the country at the time, 1791, 92, they never would have adopted the Constitution. And where that would have left us today, it's your guess. It's all our guesses. Today we have 27 amendments, but the first 10 came in altogether. So the Constitution only has been amended, counting these 10 as one, 17 times in 234 years. And we made one mistake, 18. The 18th and the 21st.
And the 16th.
Yeah. What's
The 16th as well. It's the Congress can impose an income tax.
Do you know why, of all the taxes we pay, from the gasoline tax all the way to the income tax, why was it that we had to go through amending the Constitution for the income tax? All other taxes, they're adopted by simple legislation, whether it's a city or a state or a county tax, real estate tax. Why? You know, a constitutional amendment, how? You got to have 2/3 vote of both houses of Congress and 3/4 vote to ratify a constitutional amendment. Why do we have to go through all that? Well, no. That was for the war, right, temporary, yeah. Because when you read the amendment, what did you do with my Constitution? Oh, wait, did I put it up here? No, I didn't. Anyway, it says, let me think now. And I brought it for this purpose in case I got a question for it. All direct taxes must be apportioned according to the population. Now, what is a direct tax? A direct tax is a tax that's levied on you and you pay it. An indirect tax is a tax that's levied on A, but B pays the tax. All consumption taxes are indirect. The sales tax in the state of Michigan and every other state is imposed on the retailer. The retailer shifts the tax over to the consumer. That's an indirect tax. The Constitution says all direct taxes shall be apportioned according to population. Well, what's the income tax? The income tax is a direct tax. Do we apportion it according to population? No. We apportion it according to income. So, 16th Amendment, 2/3 of both houses of Congress, ratified by 3/4 of the state. And of course, the other mistake we made is prohibition. 1919 eliminate the manufacture, consumption, transportation, and marketing of alcoholic beverage. 11 years, 32. Well, we figured out by then we shot ourselves in the foot. Did it stop any of the evils of demon rum? No. It just piled more stuff on. One of the most lawless, if not the most lawless period, and shifted all that revenue to the bad guys in Chicago and Detroit. We had the Purple Gang. You ever go in Detroit, there's a bar in Detroit on 3rd, right behind the Presbyterian Church. It's Tommy's Bar. It was a speakeasy. Yeah, and they used to go to the river and they bring it up, and if you're lucky, and the guy will take you downstairs, you show you the entrance to the tunnel. It's in the basement, remember that? The entrance to the tunnel, and then you can look over this brick wall, and over on the other side are just a ton of liquor bottles, empty ones that they would throw over there. Yeah.
Empty, I'm sure.
Empty, all empty, yeah. Okay, any questions? We got 4 minutes. Pat? Okay.
All right, this is more of a hypothetical question. Let's say you are a tyrant or tyrant wannabe, and you want to have control over the populace, and you come along this document. Which of these 27 rights, 2 of them, would you want to remove first?
If I was going to take over the country?
What 2 rights would you want to get rid of first?
I would go with freedom of expression. You can't communicate with anybody. Yeah. And that would be the first one. And probably privacy.
No.
I know you're going for the second. I know where you're coming from. Yeah.
The second, because those are the ones that protect the other rights.
Right.
Without doubt.
Yeah. Okay. Yes.
The Second Amendment.
Yeah.
I remember reading recently that John Adams had that put in for the purpose of, in case of that people needed to bear arms in case of slave uprisings.
Mm-hmm. Yeah, that could have well been. Yeah, exactly. Because that's the other thing. Every one of those fellas who wrote all this stuff, they all had slaves. Every one of them.
They probably all had wives, too.
Oh, by the way, there's an interesting program running on PBS. Started last night and tonight, 8 o'clock. It's on Benjamin Franklin. Oh, my God, this guy. Yeah, I didn't realize, just the extent of this fella. I mean, his inventions, his intellect. But of course, then he had the dark side. I mean, who doesn't? Yeah, who doesn't?
No, I do.
Yeah.
I got a question, and I'm asking for a friend.
Okay, here we go. I'll answer for a friend.
You said that there's laws set up for the state, but now I'm seeing laws for counties. In case in point, you can sell pot over here and smoke it, but over here you can't.
Yeah.
So where does that fit in?
That's a police power. That's part of that. Yeah. See, because like going back to Prohibition, there were states that were dry before the amendment, the constitutional amendment. And there still are places that are dry. So that's part of the reserve powers. The federal government doesn't have anything to do with that. With that sort of thing. That's a reserve power. That's part of the police powers. That's a local jurisdiction. Yeah. I remember the South used to be pretty dry. I was in the Air Force back in 1950s, mid-50s, and it's so crazy. It was dry. In South Carolina. I had the hard duty to be stationed at Myrtle Beach Air Force Base. So it was dry. There were no bars, no liquor stores, No, I'm sorry. There were, but you had to take a bottle. If you wanted some adult beverage in a restaurant, you took a bottle with you, and then they would serve you a vermouth or mixed, and you mixed it, and you can get just as drunk doing that as you can sitting at a bar. So, and of course we all know how violated it was. My grandpa used to work in the mines, and there were so many stills in the mines that people. So yeah, it was. So what is the lesson in that?
People are going to do it anyway.
You got to be very careful when you begin to prohibit something. Well, see, yeah, right, because during Prohibition, who got rich? Al Capone, Bugs Moran, and a bunch of these other people. So, okay, well, time's up. Thank you very much. I enjoyed my time.